Yeah, hello and good afternoon again. We restart our conference. We have a very interesting panel on legal ontologies, why they are relevant in practice. Now we hear the real game after the lecture, very interesting lecture of Giovanni Satur. And the panel will be chaired by Professor Burkhard Schafer, University of Edinburgh, now a real Scot as far as I know, but formerly was a German. And yes, he is also a community organizer for a long time in our discipline. Maybe not as long as Giovanni Satur and me, but very close to that. He has studied many topics. He didn't finish a PhD as far as I know, but that doesn't
rub it in.
Matter. Yeah, but the University of Edinburgh is a wise university, saying yes, if someone knows something, you should get the professor title, and he got one on computational legal theory. And what he's doing that, it's great actually. He's active in the field of artificial intelligence and law, and also very active in the new field of, let's say, the legal consequences of artificial intelligence. We had to do a study on these consequences for the Gesellschaft für Informatik, where he contributed very well. Then he's also quite active in the United Kingdom network on new technologies, so he may speak about that later. So his record of experience is really great, and he's doing a very nice program. It's a master's program. And besides that, as far as I know, he's also enjoying life in Edinburgh. So if you have time to see him, he may be available. So I hand over to Burkhard Schafer. Burkhard, with what you say, it's for our practitioners, he's a community organizer, developer. So if you need something, ask him. He will deliver, besides doing his job as a professor. Burkhard.
Thank you.
Please take over.
Thanks a lot for the introduction. I'm just getting, yep, works. Thanks a lot for the kind words of introduction. My remit for today's panel was, on the one hand, to give an introduction to legal ontologies for the non-technologists among you. So my understanding is that some of you in the audience are new to technology, have an interest, but not that much experience maybe, and also talking a little bit about a few examples just to show to you what power they might bring to our job. We have done an excellent panel of for other speakers who will also introduce some of the experiences they made. As so often, when I have to speak after Giovanni, I've been massively trying to rearrange my slides for the last hour or so, because so many of the things I had originally planned to say, he said much better than I could possibly do. But at least in the first part, I want to step back maybe and really give a type of introduction to ontologies for dummies, a very short one, and then moving on to some of the things that are exciting for me about that specific approach to legal reasoning. So, what are ontologies? With apologies for this German cultural reference, what are ontologies? Well, let's pretend we are totally stupid and really start at the beginning. Ontologies are the answer to the question, what on earth are you talking about? Because whenever we talk about something, if we have a theory, if we have a communication, a conversation, we have a domain about which we talk, about which we try to reach understanding. And that process very often is a negotiation. So when I talk about music and you talk about music, you might have slightly different things in mind. But as our discussion progresses, our conceptual understandings possibly align. And we might then be able to agree on borderline cases much more than we were before that. So ontologies essentially are the thing we are talking about, the things that our discourses, our theories presuppose to exist, and which then enable us to do communication. Now that sounds relatively straightforward. And if we go back to the example from the Feuerzangenbowle, here you get a ontology of a steam engine. A steam engine is a big black room which has two little holes in it. Through one, steam gets in, through the other, steam goes out. That's how the professor or the teacher of physics tried to explain what a steam engine really is. And once we start to take this apart, we realize just how complex the world is about which we talk. And we might think initially of steam engine just as a physical object. But this physical object has rather interesting and intriguing constitutive parts. It has two holes. Without the holes, the steam engine wouldn't work. But what type of thing is a hole? A hole is something that exists in virtue of not being there, of an absence. So how can we make conceptual sense of that? How can we describe what a hole is, for instance, to a computer? It is a room, a dark room. But what is a room? What makes a room into a room? What are the conceptual properties that a room has? It's not a physical thing. It's a function. It's a structure. It's a constraint. It might be lots of different things, but none of them are really straightforward. And the amazing thing is, as humans, we operate these rather complex conceptual environments without even hesitating about it. It comes very, very natural to us in a way it might not do to computers. So philosophers from a very early stage onwards realized that this was really one of the key questions of philosophical endeavor. And it really starts with Aristotle. The modern theory of ontologies owes him a lot. He was the first who thought, well, if we want to gain knowledge about the world, we have to structure it. We have to superimpose a structure where everything, every concrete instance that we study finds its place. So we have to come up with something that allows us to whatever object we are given to say it is of that specific kind. Holes are one kind of object, steam engine are another one, rooms are another one yet. And he came up with a way of structuring the entire field of knowledge that, at least on the top level, used a couple of very abstract, very general ways of classification. Things exist, that's being. And we might ask, and I will ask later on, if there are also things that do not exist. They have a being, a substance, and then they have different properties. Some of these properties are like being read. They are accidents that adhere to the individual on its own. And there are relations, being taller than, being a friend of. And working downwards that scheme, he thought he had found a way of answering for any specific object given to him the question, where does it belong in that scheme? That idea was later on developed further by Peter of Spain. The tree of porphyry became very important here. Here you can see how it works for an individual. We can ask of Socrates, who are you? What are you? And he is a human. On virtue of being human, he is also rational. Or rather a rational animal. He is also an animal, but a specific animal, one that is rational. He is a specific type of living thing, one that is sensitive. He's a specific type of body, one that is animate, and so on and so forth. So here we can already see also the relation between ontology and logic. On the one hand, we classify our world, and once we have done the classification, we can use a logic to gain new knowledge about it, to reason about the world. It has become popular to reconstruct Aristotle or Peter of Spain through the type of classical logic you are more or less familiar with. Historically, that's not quite correct. He used a logic of concepts, both Aristotle and Peter. But for our purposes, for computer purposes, it's good enough to say, well, we can combine these classification schemes with inference engines, which then allow us to reason about the world. Once we know that Socrates is a human, we know also lots of other things about him. For instance, that he is an animal living, a body, and has a substance. This thing really took off with early modernity and the breakthrough of modern science. And one of the most iconic examples probably is the Linnaean taxonomy, the attempt to really put every living biological thing into a logical order. Not just ordering them by similarity, even though that was an important ordering principle, but to impose other structures on that specific domain. Good news, and that's what You heard from Giovanni, and I will go through this very, very quickly because it really repeats it. You as lawyers have been doing this at least as long as Aristotle. And we all think in a way like ontology engineers. So, for instance, Gaius and institutions told us that law is a matter of persons, things, and actions, and nothing else. So we can subdivide the entire field of law, our object matter, what is law about, what is the stuff of law, into these three broad categories: persons, things, and actions. And that was so influential that it did not only impact on the civil law tradition, even though I think there the influence was more direct, but we also find it in the common law tradition. This is from Blackburn's very influential legal dictionary. He simply further subdivides the domain of things, for instance, into things real or immovable, things personal or movable, and finally things mixed. So subdividing again a category, creating a conceptual network here. And obviously, if you're a German lawyer or an Italian lawyer or a French lawyer, and you're used to handle the codification of your country, you have essentially mastered an ontology. You have understood an ordering scheme that is imposed into the internal logic of the categories, and you have learned to reason with it. And Giovanni, as I said, covered that better than I could. So I'm just pointing out that at the same time as Linné tried to classify the biological world, lawyers, especially in the civil law tradition, did the same for the legal world in the codification movements. Now let us go back to Linnaeus just for a second. Question to the panel. You are allowed to answer. Is this a fish? Who thinks this is a fish? I see this right? Nobody thinks this is a fish? Well, in a folksonomy, the way children think about it, the way early cultures think about it, if you think of the Genesis account, they might well be, because we intuitively divide living things in things that are on land, things that are animals that are in the air, like birds, and animals that are in water. They are fish, and that's where the whale belongs. And in German, at least, this is also reflected in its name, Walfisch, a whale fish, a very intuitive folksonomy that we find across a wide range of different cultures. Is it wrong in any specific way? Well, look at this one. Another ontology, one from Catholic dietary law. What type of animal are you allowed to eat on Friday? Most animals are unsuitable for Friday. Cows, rabbits, horses, they are all totally unsuitable. Friday, it's fish. But what are fish? According to Catholic dietary law, definitely trout, the one in the middle, but also whale. There's a specific edict that declares whale to be acceptable for Friday, and maybe more surprisingly, beavers. Beavers are fish for the purpose of Catholic dietary law, and there's a rather interesting legal analysis why this is the case. And this is not a mistake about their biological nature. They are simply for the purpose of the law classified for good reasons with these other animals. If you want details, I'm quite happy to supply them. The theological debate on that raged on for quite some time, but was eventually settled in favor of including beaver in the fish family. Then we get Linnaeus' system. And obviously, and that's what made you probably hesitate, you've all learned that's the right way to think about it. Of course, whales are not fish, they are mammals. They belong into a different group. They are a type of different entity. I'm afraid I have to disappoint you a little bit if you believe that that is the true ontology of the world. These days, we do cladism in evolutionary biology. And once you are in a clade, you are always in a clade. And therefore, according to modern biology, whales are fish. Because if they were not fish, then also real fish wouldn't be fish. That is essentially what that thing tries to show to us. So cladistically speaking, whales are fish, because the last common ancestor between what we think of fish and whales was a fish. And similarly are we. All mammals are fish, cladistically speaking. So you and I are fish, in addition to being apes, monkeys, and so on and so forth. Humans are fish, and birds are dinosaurs. cladistically speaking. That is rather worrying if you think about this beautiful dinosaur feeding fish, our relatives, to its chicks. It's not the way how we intuitively think about the world. It's rather further away from the Linnaean scheme, but it is a different way to structure the world. And it also helps us to understand the difference between a taxonomy and an ontology. Ontologies are a specific type of taxonomy. Ontologies are taxonomies where the relation between concepts has a precise logical structure. So Linneo simply classified things by similarity. Cladistically speaking, we classify things by inheritance and ancestry relation, being a descendant of. And that relation has specific formal properties, which we can introduce into our world in addition to the relation between concepts. Now, why does all that matter in law? It matters in law because I would say none of these ontologies has privilege over the other. They are all different but equally valid ways to structure the world. And as lawyers, we very often have to interact with these different ways of structuring the world. We have the structure of law, but we also have the structure of the domain of regulation. And we try to align them. One of the important tasks of every lawyer is to understand how a client or a suspect or an industrial process understands and structures the world and see how the ontology of the law matches to this. And I very quickly want to give you a few examples of practical applications we've been involved with that exemplify this and also, I think, answer some of the questions that were raised with Giovanni. One was Braro. Braro was an attempt to build an ontology to tackle financial fraud in Europe. And the problem that we are having here is that the way an economist or a business science person thinks about fraud is not necessarily exactly the same way as a lawyer thinks about them. And lawyers in different countries, again, classify fraud in different ways, even when they are governed by the same overarching directive. So we have lots and lots of different ontologies, different ways to structure the world, different ways to think about them. And if we want to have a successful cross-border prosecution, we have to find ways to align them. We find a way in which the English lawyer can explain to the German lawyer that no, we don't really have a notary in England. Well, we have something we call notary, but they are not really notaries. Therefore, a certain requirement that you have is simply not applicable here. We have to decide if a Staatsanwalt is a judge or something else. A juge d'instruction, the public prosecutor, they all share certain properties, but are not strictly speaking identical. So what we tried to do in Braro was to start from the bottom to understand how in the real world typically a fraud happens, what characteristics it has, and then match it up successively to these white notes here. The black notes are facts about the world. The white notes are legal classifications to see how the different ontologies of these different countries can be made to cooperate. The legal theoretical or comparative legal theory behind that is, roughly speaking, Zweigert and Kurt's functionalism. Different legal systems are comparable because despite their conceptual differences, they share a joint physical reality. And that was a way of structuring that process of communication so that a computer can support it. So that the computer helps the English investigator, the English prosecutor, to ask the right question of their German counterpart, even though the different ways of thinking misalign, and in that way reduce the number of friction, loss of time, problems of coordinating a cross-border investigation. So that is one of the ways I think the ontologies are tremendously helpful. Unlike rules, they are not tied directly to an individual language or an individual system. They are one level of abstraction higher, and they might allow us then to see similarities and dissimilarities, to see where they overlap, and with that automate also the communication process. Orlando Conetta, a student of mine now at Vincent Mason, he developed the LKIF-based transaction framework. We will hear about LKIF, I think, a bit later from Monica. Essentially, what that tried to describe was how in the context of a law firm, a specific new object is created, a Eurobond, And that Eurobond is created through the communication back and forth between a client and the lawyer, or rather a team of lawyers. Of course, the lawyers do not necessarily stay the same over the process of creating one of these bonds. What the system does is to extract from the worldview of the client and the worldview of the law firm a shared ontology that allows them to optimize that back and forth, to always know where they are in that process and to check at which point they have reached sufficient understanding that they can then action on it and go ahead. It was really successful. It was one of the reasons I think he was immediately bought out by Pinsent Mason, where he is now chief knowledge engineer. Again, we have here a communication between different parties. They structure the world in slightly different ways. And the ontology helps them to keep on track in the process of creating a shared understanding. Finally, what we do at the moment in creative informatics, a large research project at Edinburgh University, takes essentially the same approach on the practical side. It's where digital humanities meet IP law. Of course, one particularly interesting type of objects are artifacts, things that we create, things that do not exist in nature, but only exist there due to our ingenuity. And DLIC, company in England, they try, for instance, to automatically manage collaborative rights for musicians. There's lots of musicians that collaborate in an artistic endeavor, reuse parts of their tunes, reuse parts of their music. They create something together. And now you want to understand from a licensing perspective, from an IP perspective, what is that object? Where does it fit into our world as lawyers? And for that, we have to answer questions like, what is a work of music? What is the performance of a work of music? A recording of the performance of a work of music? A novel, a character in a novel, a storyline about a character in a novel, or a film based on the storyline of a character in a novel. All very complex objects that we create. And depending on how we create them, that has then legal consequences for their IP status. And so finally, that is my ongoing research at the moment in that context. What are these things? What are unicorns? Apart from apparently being the business model of post-Brexit Britain, we are going to sell them a lot to the world. That seems to be the plan of our government, at least at the moment. These types of things, inventions, fictional objects, Star Trek, but also, things that are based on historical characters. Under which conditions can we say that two objects that do not exist are really the same? Famous IP litigation between Harry Potter and Tanya Grotter, who share quite a lot of characteristics, but may or may not be the same. So again, what we find here is if the law wants to serve its population, we need to have a way to realign or align systematically the way we structure the world with the way lay people, our clients, structure the world. And one of the interesting things of ontology-based legal AI is to make that explicit, to help us to see where the conceptual structure of our world and that of our clients, the communities we serve, match and where they disagree, and finding more effective ways to bring them into an overlap. So that was me, 3 short examples, hopefully, of practical applications, together with a short introduction that hopefully allows you to situate the question of ontologies in an appropriate way. They are particularly suitable, I think, whenever different conceptualization of reality need to be brought together and to be brought in alignment. That's been me. Oof, and I made it in almost the time that was allocated for me, which is a first. And now I'm switching my head and stop sharing and become a moderator, I think, or a chair. And Eric, I don't know if you want to introduce the others. The next person on my list would have been Monica. Yes, in that case, thanks. It's my job, which I am particularly pleased to do because I can now introduce Monica Palmirani, one of the leading researchers in our community for many, many years. She has shaped my own thinking about so many things that I couldn't give you a complete list. I think she was one of the first to introduce me to that field, if I remember correctly, a long, long time ago. So I'm particularly pleased to pass on the baton to Monica and her talk on legal ontologies for legal tech. Thank you.
Thank you so much. Can you hear me? Is it just a check? Yes.
Yep.
So thank you so much to the organizer for this beautiful event, and thanks also for the introduction. Let me. Oops. What happened? I share again. So my goal briefly is to answer to these three questions: why we need a legal ontology and legal tech, which methodology among many methodologies of legal ontology design, and finally, which advantages from my perspective point of view, my experience modeling ontologies. So start with the legal text scenario. In the last 10 years, we assisted to a real huge amount of new application in the legal tech, starting from simply management or system informatization of simple things like e-bill or digital bills. And the last is legal design or blockchain and machine learning and predictive algorithms. And these scenarios really need to have interoperability between technologies and platforms. And in my opinion, legal ontology is a tool that can improve interoperability between different tools that also the law firms are now adopting for enriching the performance and the effectiveness inside of the job of the lawyer. So all of those applications are based mostly on text, legal sources, decisions, legislation, and other verbal but written after sometimes. So the basic are text, but with characteristics. Which characteristics? Authenticity of those texts, integrity, accuracy, quality, updating, and also the provenance are so important because big tech over-the-top companies are now in the field of the market, and plenty of actors are now scanning or transforming the text from paper to digital, and time to time they are not accurate, are not good quality, not authentic, not very well known the provenance of those texts. So the legal ontology also can help very much to understand the provenance of the text, and so the characteristics of authenticity of those texts that are the basis of many of the application in legal text. Also in the legal digital community, so there is an effort put in the semantic web over the time. So we started in the panel, there are many colleagues that started with me to digitalize the legal sources, and the first goal was to have access to those legal documents in web, so in the official portals. But the more and more the semantics annotation of the concept inside of the text was a key point. And nowadays that we assist to the very success of artificial intelligence and also legal analytics, time to time I heard the fact that the semantic is dead. It's not true. It is a moment exactly to use the annotation made in the past using semantic web in order to enrich the artificial intelligence effectiveness and also the performance. So semantic web is a good glue in order to annotate concept, rules, relationship that the other pillars and emerging technology like artificial intelligence, like machine learning can foster and can disseminate better and exploit better. So in my opinion, there is a risk really to have a gap between the real originally text also digitalized in the web by the Gazette and the new form simplified of the legal text using also legal design, pictures or building blocks or diagrams or any other simplification of this text. So simplification is a good goal, but in the middle there are many of legal knowledge that we need to preserve in this transformation from the legal text, officially legal text, quite convoluted time to time, long and very specific for the lawyer, in something that is consumable by human in any level, by the citizen to the companies, but also to the legal expert. So the risk really is to have a legal tech application that is a black box and not transparent what is in the back, and not transparent in respect the human being accessibility. So for this reason, the community and my colleague and friends can share with me this adventure in the last 10 years to develop standards or methodology for design legal ontology good for the legal application. So in this picture, there are some of them, not exhaustive list, but it is a list of standards that are good for the developing of legal ontologies. And for sure, ALI, ACLI, or Accomantoso, or any other standards is a very good starting point for legal tech in order to not reinvent everything, but to reuse as much as possible. So in this new scenario, the legal official text is serialized in a standard very well known inside of a community, and so also auditable, and it's quite transparent. And also the formalization of the logic rules could be transformed in serialization, machine readable, using also legal ontology for annotating the legal concept. And we can go ahead in other application, for instance, legal reasoning or smart contracts or machine learning, and finally to arrive to the visualization also using legal design, icons, diagram, comics, as you like. But the difference between this scenario and the previous one, that the black box is open, and now we can use a semantic web annotation, machine readable, but also inspectionable, auditable by the human in order to understand back through the path for arriving to the original document. So it's not a black box, but is a sort of path of a provenance from the simplification text to the original text. This is true in any legal tech application, also legal analytics, graphs, or machine learning, as Giovanni said before in the presentation. And which methodologies? This is a good question, because we have plenty of methodologies. Giovanni explained before, we find upper ontology, foundational ontology since the beginning of the philosophy, but it's quite difficult to apply to the concrete case, but are very good in order to check if our specific domain ontology is well formalized and well designed. So usually the legal domain start exactly from this level, not to the upper level, but from the real concrete domain. So we can find IPR legal ontology, GDPR, e-commerce, or e-procurement. We have plenty at the hand already good legal ontology in the field, and applied also in some legal tech application. But the risk is to not check this legal domain, very concrete ontology, with the main principle of the upper ontology that design for us a sort of a skeleton that we need to check in order to have an evaluation and a robustness of our thought in the legal domain conceptualization. But on the other hand, as I said before, we start from the text, so from the bottom, because ontologies design take usually years, not months. So another approach is to have light ontologies extracted directly from the text, and it is nice to start from the bottom and to move through the top of the methodology in order to check if the hypothesis that we have is robust enough. All these levels are very useful, and in my project I use a mix of them and hybrid approach, top down and bottom up. And I use also very much ontology design patterns. This is another methodology. Little ontology, very abstract ontology, very little fragment, like a Lego building blocks, and we can compose our final legal ontology using these building blocks and to compose without have a mistake, because these little ontology are already tested by the researcher and applied in several projects. So in these slides you can see my selection, my personal selection of the ontology design pattern, because in the legal domain we have usually agents, and in such a given time the agent plays a role. In the GDPR, for instance, a company in a given time plays the role of the controller, but in another situation the same company could be a processor and change the role. And also the events obviously is a very important part in the legal domain, and also the deontic ontology like legal ReMeP or others that models the rights, prohibition, obligation, and so. So which advantages? In my experience, I tested in several occasion and project many advantages using legal ontologies. First of all, starting from the light ontology, we can improve quality of search inside of the legal text, so we can improve the performance to detect a legal concept. Secondly, we can search among heterogeneous documents, legislation or decisions or European legislation, national legislation, using a common legal ontology. As Giovanni said before, we use legal ontology combined with legal reasoning, so rules and concept together. And also knowledge graph is very nice to extract from the text the main concept and to put in the knowledge graph in order to answer very simple questions, but let me say not like a normal search engine, but fostering and using the relationship between the concept. And also the smart contract are very important application nowadays in emerging application in the legal domain, and the programming like the legal reasoning need to harmonize the vocabulary of predicates, otherwise we have really a forest of smart contract not comparable each other. And the time is very few, but I put some example of my project. This is a project that combine manual annotation of the legal expert with ALI and ACLI extracted by the open government portal data of European Commission. Is a seller that Enrico knows very well, and we can navigate using those combination and mapping of different ontologies together. This is another example of bottom-up ontology. We extracted using machine learning and open knowledge extraction methodology, a forest of concept, and we organized this concept in order to help the legal expert to answer to very frequent questions concerning the private international law. In this case, we have a very, very conflicting definition, and these techniques is quite nice, exactly in the situation when we have no one true answer, but we have a multiple good answer and conflicting rules. And this is another experience top down, so from a very theoretical organization of the concept. The name of the ontology is Pronto. We started with foundational ontology and go down in the domain, and we connected the privacy policy with the Pronto ontology, and we put in the back of the icons the RDF, like the Creative Commons is familiar to do, in order to have the image of the icons, but in the back also the serialization of the duty of the rights that the icon represents. And finally, we use the prompt ontology also for annotating the rules in order to have an harmonized vocabulary, not invented by the programmer or from the legal engineer time to time, but to have a common shared vocabulary of concept and relationship in order to start from the text and to arrive to the legal knowledge modeling using for instance, legal defeasible logic. This is a very short example how it is in practice work. We have a legal fragment. We serialize with the parsing in a Commentoso, XML. We try to help the people, legal expert, to formalize in logic rules. But in these logic rules, you can see a lot of predicates or concepts like child. Child in this concept, this context is very different of the legal meaning of child in the civil code, because child in this context is a different meaning. So we need to have an ontology that explain what is the meaning of this child that is different respect to other situation in legal domain. So for this reason, we have also an extension of the legal vocabulary, because in the common privacy policy, for instance, Facebook doesn't use child but kid. So we extend also the vocabulary in order to have similar tokens, or to model the relationship between different tokens. So we pay attention also to the language, and we have also the ontology in the back that can explain to the machine that when we have a child, we have also parents or responsible holder of some actions. This is not written in the text, it's written in the ontology. So the other application can take advantages from this extension of knowledge using the ontology, even if the text doesn't say nothing concerning the relationship between the child and the parents. Exception is a part of the rules, not of the ontology. It's very difficult to model very large exception in the ontologies, even if we have some cases time to time. But in my experience, I delegate the role to manage the exception to the rules, legal rules. Okay, I'm finished. So the idea is to have also in this case, in the smart contract, the same vocabulary, not invented by the programmer. I have the occasion to make a deliverable concerning this topic. There is a link. And well, the idea is that to use a legal ontology, to have a common vocabulary, to open the black box and to transform it in a white box in any legal tech application. Thank you so much. Got it.
Thanks a lot, Monica. I suppose but that was totally clear from the beginning. We need to talk to our colleagues from the philosophy of physics to come up with a slightly different ontology of time, one that is flexible and mendable and subdividable. But that was again another really interesting tour de force and overview. I'm passing on to Victor very, very quickly. I'm particularly pleased to have him here because one of the things we already touched upon in Monica's talk is the importance of access to information, the semantic web, and with that also the informed citizen and the role for democracy. And one of the great books I read recently was one where Victor was a co-author about information technology and the future of democracy. So I'm particularly pleased to have him here on our panel. And Victor, without further ado, over to you.
Thank you very much for your warm introductory words. And also thanks to Stefan and all the ReMeP organization for inviting me and being here. It's a pleasure to be here. So I do not have many slides. I have a clear message, and much of the information I will try to deliver has been already presented by Monica. Still, I would like to present a couple of ideas with images. So I will start sharing my screen. And I will also answer Burkhard a question whether a whale is a fish or not. So, so I'm very glad to be here. I will start by saying that I am not a legal scholar. I'm a computer scientist, but I'm very happy because this session is called whether they are relevant in practice, and the ReMeP is the P stands for practice as well. So I will be quite practical in my presentation. First of all, I would like to acknowledge that ontologies fulfill different purposes, and you have heard before some different definitions. They are different visions from different angles, and in my opinion, they can be summarized into two big groups. So I will resort to the classical definition by Nicola Guarino 25 years ago about ontology being a formal specification of a shared conceptualization. So, I mean, 25 years for legal scholars is nothing, but computer science is an eternity, as you know. So, as shared conceptualization, ontologies are useful. So, about 15 years ago, I was participating in the ISO standardization of rights expression languages, first in XML, then with ontologies. And I want to give you my impression that the most valuable output of these ontologies, of these formalization efforts, was the agreement. In those sessions, in those meetings so long ago, I have to tell you, people were literally yelling at each other. Serious people like you, well, some of them were Italians, which they are more prone to yelling, but it was a strong discussion. And reaching a final consensus was a great achievement. And the fact that this achievement was made something solid, something formal, is remarkable. Having a written agreement is better than having an oral agreement. It leads to less ambiguities. If I say, oh, I will pay you some drinks after this talk. Okay, some, how many? 2, 4? It's better if it's written. But of course, if it's formal, it's better than if it's written. Then you can be more precise. And that's why when people were yelling in discussion, they were yelling at the properties, whether the range should be this one, or the cardinality of this property should be one or many. These details were very carefully considered. So having agreements is already useful. But I don't think that ontologies would have become so famous if they were only for fixing agreements. I think that they, and 10 years ago, in the book of Núria Casellas and the people of Pompeu Casanovas, when they examined the ontologies, she examined 53 ontologies in this wonderful book, Legal Ontology Engineering. Most of these ontologies were worked at the conceptual level. Yeah, but if I go back to the second part of the definition, the first one here, the specification, I have to say that it is in the last 10 years when ontologies have started powering computer applications. Computer applications have started using ontologies in practice. So it makes money. So it means that they have been the definition of the data model for legal knowledge graphs with real value. In a legal knowledge graph, as Monica has described, different entities are connected some norms, directive regulations, but also case law, but maybe people and maybe companies, different entities are connected, and information structured in this way is more rich, and you can extract more insight. You can make better informed decisions if you consider information arranged in a legal knowledge graph. And if this graph is, not every legal knowledge graph is supported by RDF, but if it is using the semantic web standards, the W3C recommendations, then ontologies are the strong foundation, the rock solid foundation. So if 10 years ago, Nuria Casellas in her survey, she was considering 53 ontologies, most of them were theoretical. Nowadays, I think that most of them would be used in practical applications. So legal ontologies are here. Go to the European Union Open Data Portal. Just from the very front, you will see that it's talking about linked data. So this portal is not addressing computer jigs. It's focusing on the people. And you see already mentions to linked data or even to the Sparkle endpoint. So it's not a dream, it's a reality. You can also go to the other European data portal. You also see the Sparkle in the very front. You can see the dream realized. That I mean, Monica said before, yeah, about having an ELI so that legislation is identified by URIs. These are the principles of the semantic web. So it has been embraced. It's a reality. Take a look at how law is being published by the official gazettes. Go to, I don't know, I took randomly some legislation in Ireland. You will see the beautifully laid out HTML, but if you go and you see the source code, yeah, you will see that data is here. This is RDF. This is supported by ontologies. It's talking about Furbur, it's talking about classes, relations. Go to legislation in the United Kingdom, you will see more RDF, published officially from the official publishers. ELI being embraced by many jurisdictions in Europe. So in the projects we are participating in, we are much like Monica was doing, we are also integrating information from different sources using different ontologies, and it is no pain for us to mix this information and work with this information as if it was uniformly made. So supporting Monica's claim that legal ontologies favor interoperability. I want to be strong on this because it's one of the strongest claims we can make. I think you know this joke, huh? So I want you to read it again, even if you have read it many times. There are 14 competing standards. Oh, let's make another standard universal. Oh no, we have now 15 competing standards. But it is not so terrible if the 15 standards are RDF. You can easily make the mappings between the different 15 standards. It is not the case if they are, one is relational database and the other is a spreadsheet, the other, no. In this case, it is very cheap to establish the mappings. So the adoption of the semantic web recommendations and technologies favors the fast development of integrated applications. You can mix different data sources and have an application that is using all of it very quickly. So in the links project that we are about to finish, I do not have a slide for this, we could very quickly mix different sources of information because all of them were RDF. So it's very important for comparative law, for making fast searches or more accurate searches. Yeah. So yeah. So it fosters interoperability. Second, my last idea about how this is visible and how it has impact is about the legal metadata. Monica was going to the details of the rules, but even at the metadata level, it's already very powerful having everything well structured, supported by ontology. So a look, if you look in Google for paella, you will see that the answer has recognized that paella is a dish, and you will see on the right side about the serving temperature, the main ingredients, and so forth. This information is taken from Wikipedia. And currently, it happens the same when you look for a norm. You get also information from Wikipedia. But if you look for a old directive, for example, you will get nothing special. But because ELI has been proposed as for adoption by schema.org, and schema.org is understood by Google and other major search engines, very soon we will get also very beautifully structured information where you will get when it was enacted, latest consolidation, etc. This is possible because metadata has been structured in RDF, supported by ontologies. And just to finish, I will be provocative because this is it's already late and we need some action here. So Burkhard was asking whether a whale is a fish. And I want to remind you now here about the dichotomy in artificial intelligence. There are two branches in artificial intelligence, the symbolic artificial intelligence and the statistical one. So I took here his image for the, well, this is an orca or a whale or whatever, which is where things are either black or white. And this happens to be so also very often with legal concepts, as Monica was saying before about minor, who is minor. Those who are under 18 in Spain cannot drive and cannot drink alcohol. And it's a clear barrier, it's a clear limit. So this is very nice. But in real life, we are more flexible. And maybe I would allow my child, if she's 16 already, to have a beer in certain conditions. So, and this happens also in language and the revolution that we have seen in NLP techniques with the massive adoption of statistical models, vector space models, etc. So AI is now successful because statistical AI has progressed much. So if I make an experiment now, I did it in real time. I took here, this is a demo, is not mine, with models for the vector space trained with Google News. So it's about English text, and it will tell you how near they are in the vector space. So if I type here something like cod and fish, we get very similar. 60. The answer is 0.63. This number is a number between 0 and 1. If it is 1, is that they are very frequently appear in the same text, the same document. If it is very low, is that they are very disjoint. So I could type here other fishes. Again, 63, and so on. If I type something different like tiger, we drop to 33. But if I type here whale, interestingly, we get something in the middle, more near to a fish than to a tiger. So, in general, in artificial intelligence, these statistical models are succeeding. Fortunately for us, concepts still have shortcut definitions, and the law sometimes states very clear, very sharp distinctions in the concepts. And if it is 18, it is 18, period. So legal ontologies make even more sense than other ontologies. So this was my provocative thought, and I leave the word to the next presenter.
Thanks a lot, Victor. That was really excellent. And now I know that whale are 0.55 fish. I'm not totally sure what I make with this number, but I feel much happier and very relieved. The next speaker in our list is Ruta Liepina. She is now, since September, assistant professor in digital legal studies at Maastricht University from Latvia, I think originally, if I remember correctly, which also brings me back to something Victor just said. Last time I was in Latvia, we discussed very intensively the earliest age when children should get alcohol. And the German-Latvian approach to child rearing seems to be remarkably more relaxed in that respect than the Spanish one. So our age was substantially lower. Let's leave it like that. She is also a PhD student of Giovanni's and Adam Weiner's, but I want to point out here for the record that I recommended her for this panel because I wanted the best and brightest of the early career researchers. So this is not Giovanni simply plugging his students. That is me asking for the best for our panel, just for the record, that is totally clear. And with that, Ruta, over to you.
Thank you very much. I hope you can hear me well. Thank you very much for inviting me to this amazing panel. It is great to see the research that has been done by really prominent scholars in the field. So I think to add a slightly different angle, because we have practitioners in audience and legal students as well, I wanted to share my experience of sort of finding data sets to do some ontologies on them and reusing ontologies, because one of the themes we've heard in Giovanni's presentation and now also among the panel speakers is that there are ontologies out there, but they're not used often enough. And if they're not used, then we can't see them in practice. And you kind of see where the pattern is going. But this is a great time for them to be implemented with machine learning. So just to make a few points, I don't have slides, so I'll just share a few points on the experience. I think as ontology scholars, we agree they are great applications, but they're great applications if we have also a good data set. So within my PhD research and now also as part of the Law and Tech Lab in Maastricht University, I've found various ways of how to find interesting legal data sets and how to use them and how to also involve not just ontologies, but different legal, digital legal studies methods like network theory or predictions and machine learning as well. So the first data set I wanted to share is provided by a company called Caselex, and I used to work for them as a Latvian editor. So they join merger and acquisition decisions from 32 countries in Europe, and they specifically look for native speakers who have also legal backgrounds. So they summarize the merger decisions and different market definitions, and they identify certain entities that are important and can also be machine readable. So they're mostly focused on legal practice. They have 100 law firms already signed with them, but now they want to expand and see how data scientists and social scientists would like to use their data sets, so it's open for academics as well. So the idea with Caselex is to gather the national decisions, so you have access to the PDF files, and then you identify certain entities as the NACE code that represents the statistical classification of economic activities in Europe. You have value chains. You also see the outcomes of decisions in a structured way. You see which cases are cited and which rules are used, and that links again together if you've used your national decisions or if you refer to European decisions. You can easily access geographic scope, type of decisions, and as well have direct comparison. So I think what would be really interesting is for those who are enthusiastic about ontologies is to see how these entities could be marked and then compare the different language versions that are linked through the data set. It's something that hasn't been done, and I think it's always brought up as an issue in Europe. That is amazing that we have the language diversity, but it also means that smaller countries like Baltic states, so Estonia, Latvia, Lithuania, it's rarely that we get access to legal tech because most of the languages used are English, German, French, so we have some dominant languages, leaving some of the member states behind. A similar experience I also had in a Claudette project that is based at European University Institute, that is led by Giovanni Sarton and Hans Miklitz. There, the approach to data set is a little bit different. So legal experts created the data set, which is based on terms of service and privacy policies that are accessible online. So again, we used English, but what we try to do is label certain unfairness terms based on legal definitions in the Unfair Terms Directive and GDPR. So now we have an automatic tool to identify unfairness. So there's also a demo available online if you want to check it out. But the nice thing about it is that the project also aims to be truly European and expand in different language sets. So we have some German speakers working on a German extension. And the nice thing between big languages, German and English, that translation tools such as DeepL provide great support, which I can't say about Latvian English translation. Even if I use Google Translate, it's mostly nonsensical because there are not enough users of a population of 1.8 million. And you can see how that also can be said about Scandinavian languages or other Eastern European languages. And a third approach to datasets is something we're exploring currently in Maastricht University, and it's about crowdsourcing labeling. So we have access to decisions, we have access to different regulations, but it's not always tightly structured for machine readable formats. So there's already progress, as Victor said, and I'm sure Enrico will also add on to this, that there is more metadata than ever before, but we're still not at a level where we could see a nice entry and Wikipedia style summaries of decisions or legal changes in legal rules. So the idea would be to test, and this is more experimental idea, to test sort of how much crowdsourcing labeling we could get before we reach a certain level of legal expertise. So for Claudette project, we had PhD level legal experts labeling the text, but there are certain entities in legal text that are common sense. So maybe it's possible to have more collaborative approach towards designing legal data sets. In some other science areas, it's more common to have this collaborative nature, whereas in law, it's rather competitive and in ways collaborations are encouraged, but they're still slower to progress through. So what does it mean for legal practitioners? I think an amazing opportunity to use ontologies is to pass on the knowledge that you have in a legal firm and also to stay up to date with the new information coming in. The amount of new interpretations of law, and especially if you're covering several topics, if you're not focusing on one topic only, it's a full-time job just to keep on top of the updates, and then you have a full-time job of analyzing and recommending your client the best solutions. So I do foresee more legal knowledge engineer professionals coming out, and I think they would really employ ontologies, machine learning, and a mix, like a hybrid approach to dealing with legal texts. I hope my experience helps some. I'm happy to discuss it further during the discussion time. Thank you. Sorry, you're muted, Burkhard.
I realized that will be, I think, the communal greeting of the post-COVID generation. You are muted, I am muted, as a way of introducing people. Thanks a lot for that. Excellent, also for the timekeeping. We were able to catch up a little bit. So we come to the final speaker of today, Enrico Francesconi, and I obviously reserved the really big guns for the very last, because he is, if I remember correctly, also the serving president of the International Association for AI and Law, the main international organization that fosters and supports the development of artificial intelligence and runs the biannual ICAL conference as the main venue of our community to exchange ideas. So for that reason as well, I'm particularly pleased to pass on now to our last speaker for this panel, Enrico. The floor is yours.
Thank you very much, Burkhard, and thanks a lot also to the organizer for inviting me to this conference. I have some slides as well, and in this presentation that I try to share now, I will basically let me go through. Okay, you can see that. I will basically address some of the topics already addressed by my predecessors, like Monica, Victor, and Ruta too. I will focus more, let's say, the attention on the relationship between legal ontologies and the implementation of the semantic web. So actually, there's no doubt that the IT environment is dominated by topics like smart data, semantic web, natural language processing, in general, artificial intelligence. And this is even more true in the legal domain, because this AI and law is actually a combination that comes from afar. In fact, the law, we can say that the law is made of rules and interprets and creates facts. Similarly, the Turing machines, the computer processes facts, the data basically, through the rules. And it does it according to different paradigms, like Victor before said, the symbolic paradigm. So basically using rules expressed by symbols in an expert system mainly. And in sub-symbolic paradigm, so the so-called connectionist models, where rules are considered as a combination of elementary processing structures, and the neural networks are an examples of this kind of models. So now, AI, on the other hand, requires knowledge. This is quite true, quite well known from several, let's say, analysis of different academics. And but actually, managing knowledge, it's also a certain kind of a problem, because it's voluminous, it's hard to characterize accurately, it is constantly changing, and it requires a semantic organization. Now, in the mid-90s, basically AI meets the web, which means that AI meet the availability of a large quantity of information in digital format for the development of AI systems. So it is also true that the internet and the web need advanced application for managing data. So basically, the interaction between AI and the web came into practice. And the evolution of AI has followed since that time the evolution of the web. So we went out from the so-called AI winter, which was the period of the 80s, basically. Then having this great amount of information available in a structured format helped and is helping a lot the development of AI systems. So let's see how, let's say, the AI and the law have been improved, let's say, and have been considered in the sense of the evolution of the web from the so-called Web 1.0 to the Web 3.0. As we all know, that, let's say, that the first era of the web was the so-called static web, where we had static information with a limited interaction with the users. Then in the mid 2000, we passed to the so-called Web 2.0 or social web, characterized by the possibility of sharing content and to have a let's say, the possibility for collaborative content creation. For example, Wikipedia is one of the success story in this era of the web. But nevertheless, especially in the legal domain, people and also practitioners had specific information needs. First of all, because access to law and court decision, it's an important aspect. It's a matter of transparency and legal certainty. And moreover, this is even more complex, considered the multilingual complexity, for example, of the European Union. In particular, legal users had specific have a specific information need. It is very clear that it's important to have a unique point of access to resources in a distributed environment, especially as far as legal text is concerned. which means submitting a query in a specific language and from a unique point of access, and retrieving pertinent documents from different sources. So what we need is actually advanced legal information retrieval and reasoning services that allows you to respond to queries like which version, for example, of Directive 2003/98 of the European Commission adopted on 17 November 2003 was in force on 26 June of 2013. So it's very hard to ask for a general purpose search engine like Google, for example, to retrieve and to respond to a question, to a query like that. Or in the member states acts, which law is applicable to divorce of cross-border couples? Or even more specifically, which national laws on consumer protection do apply in a specific region? At a higher level of abstraction, which are the rights of the consumer according to the EU law? And even more specifically, which are the implicit rights of the consumer according to the EU law? So the last question in particular requires specific reasoning on the legal text from the human perspective, and also obviously for the machine perspective. So there's no possibility for general purpose, even well advanced, to respond to such kind of user needs. So what is the right answer? It's actually the era that we are currently passing through. So this is called Web 3.0, or also called semantic web, or web of data, or Internet of Things. They are actually, all of them are synonyms, basically. So what is actually the semantic web? It's the process of embedding in the World Wide Web information that is understandable by humans, but also processable and understandable by machines, which means that actually that you can have an actual interaction between human and machines, but also from machine to machines. The objectives are the technological, semantic, multilingual interoperability between information systems, as previously has been said by my colleagues. So having the possibility to develop advanced access services. Now, in the semantic web, the development of legal ontologies is essential. So modeling legal knowledge is essential in the semantic web, and it's a precondition for the implementation of the semantic web in the legal domain, which means that the legal ontologies in the semantic web are artifacts for legal knowledge modeling, so that you have the possibility to, let's say, interact directly with the computer, and the computer can interact one to the other, exchanging legal knowledge, and having the possibility to implement legal reasoning facilities. Now, in the last few years, a specific trend has been developed, which is basically the so-called linked open data. So linked data are nothing but structured and correlated data on the web, while linked open data are linked data published with open licenses. So basically the semantic web, the so-called the Web 3.0, is made up of linked open data. So you can say that the semantic web is the whole, while linked open data is the parts. So let's see what we can do with in the legal domain using legal ontologies and basically modeling legal knowledge to develop advanced services. So let's consider, for example, this business case. Let's consider a user that wants to subscribe an online contract. He might be willing to know which is to know much more about the consumer protection law, and in particular, he might be interested in knowing which are the consumer's rights, like, for example, the right of withdrawal, or the supplier's duty towards the consumers, which are actually implicit rights of the consumer, or which are the procedure to fulfill the consumer's duties and the sanction in case of not compliance. Now, all these kind of questions, queries, or information needs can be effectively, let's say, addressed by a system which is able to describe a specific knowledge about the consumer protection law, for example, in a way that is shareable in computer systems. So what we need is actually a retrieval system of norms endowed with reasoning facilities. And for doing that, you should have a specific ontology, in particular an ontology that is able to describe provisions within a legal text, to have a specific annotation of the legal resources, which is actually the experience that Ruta before described in her experience. And in this case, we have the possibility to annotate text using a specific ontology made of legal concepts like duty, rights, power, or definitions or procedures, and concepts like suppliers, consumers, and other kind of concepts that can be represented in a shared and standard fashion. So now, having this possibility to by a legal ontology to provide semantic annotation of text, or in this case, our paragraph of an article or two articles here of the consumer protection law, you have the possibility to implement specific retrieval facilities like, please give me the rights, my rights. I'm a consumer, for example, I would like to know which are my rights. And the system can retrieve back to you the rights where the consumer is the addressee, but also with a specific reasoning made on top according to specific actions that can be implemented in ontology, can be also the duties of the suppliers, where the consumer is the counterpart, can be retrieved, because they are actually rights of the consumer, which is the typical, let's say, Ofeldian reasoning, which was previously addressed also by Giovanni. And moreover, you can also have the possibility to retrieve the duty of the suppliers implementing a specific communication constraints and the procedure to fulfill to such constraints or to such procedure. Now, how can we do that? We can do that, let's say, I can share with you an experience that I'm currently following at the Publications Office of the European Union, where, let's say, at European level, we are trying to implement a so-called open data cloud focused on EU law. Actually, all this in this picture, you can see all the sources of information that are managed by the Publications Office of the European Union. The main one is the EU law, and the EULEX, for example, is the mostly the service which is mostly known. Then we have pre-legislation, EU research, general EU information, case law, public procurement, and also other European Union data. All this material is basically stored in the so-called cellar, which is the central hub for EU publications and data. It's actually a semantic repository, maybe the largest one at European level, of legal and non-legal resources, which are semantically described using a specific ontology. Actually, we have more than 250 million documents in 24 languages, metadata in 24 languages, 1,500 million semantic statements, so the RDF triples that basically represent the semantic annotation of the metadata of the resources, and the 10 million requests per day. And as I said before, there is an ontology behind the so-called CDM, or Common Data Model, that is the ontology for metadata description of such resources. Another interesting, let's say, business case, it's actually a pilot project that I followed in collaboration with European Parliament, which is called Linked Open Data and E-Participation. It was a project meant to produce a pilot for allowing citizens to collaborate in, let's say, collaborate in the legislative process. So basically, in this platform, which is nothing but a social network for following the lawmaking process at European level, users can visualize in a selective fashion the legal resources, can visualize them in a specific, let's say, in a selective way, can provide comments to the single provisions, and they can also provide amendments, and this information can be submitted to the members for their let's say approval or not. And here you have, for example, the discussion forum with the comments, sentiment, and amendments. So users can say I agree or I disagree. It's just like in Facebook you have I like or I dislike. Obviously here they will have a different meaning, but there is also the possibility to see statistics on user sentiments per document and section, so that you have a possibility to see the general metadata of the act and the reaction of the users. So you have a number of comments, how many of these comments are positive, neutral, or negative. What is important to know is that all those data, or actually the documents, are coming from the seller, so from the semantic repository I showed before. And all the data are produced according to a specific ontology, and so are stored in a so-called triple stores, and in principle they can be reused by third parties. So here we have maps of sentiments and activities per country. So you can see where that specific act received much more approval with respect to other country, or how much the activity in a country has been, how much a country has been more active or not. So what actually open data and semantic web legal ontologies are about? They have to do with business model for data consuming and sharing. For example, with the possibility to provide the third parties with data. With those data, they can develop web services or apps for mobile phones. But in conjunction with the government initiatives, like the one that we have seen before, they are about legal data accessibility, quality, reusability for citizens. And so, finally, they have to do with a promotion of freedom, justice, and democracy. And that's all from my side. Thank you very much.
Excellent. Thanks a lot, Enrico. With that, we have reached the open discussion for our panel. Thanks a lot again to all speakers and to everyone for what was really a very exciting and stimulating talk in a late afternoon, especially for you. It's 1 hour earlier for me. How does this work, Eric? with the questions. Can you see them? Because I think I can't.
We didn't have received many questions, actually none. So I may start the discussion round by asking the panelists, you've developed now your methodology, but scaling up, how do you develop an ontology for a legal system, how fast you can do it, how quick you are, and how you update it on a regular basis. What's about resources required for that purpose? Thank you.
Who volunteers for that difficult one?
I can try to answer.
Mm-hmm.
So okay, depends from the inputs that you have. If the project that Enrico presented to use ontology, since the Parliament emission or say if the authorities started to use legal ontology since the beginning, researchers and companies can take advantages exactly from the authentic resources, first of all. Secondly, it's true, core or domain ontology means 5 years of work of a team. But when you have the main pillars done, you can use the machine learning and the knowledge graph in order to produce very fast inputs coming from modification, evolution of the normative system. And these new inputs should be evaluated by legal expert. So in my opinion, we need an ecosystem, not a simple one technology, but really not simple one research group, but as Victor said before, it's a sort of a life cycle that starts from the authorities, go ahead with the participation of the legal experts and also the research teams in order to produce as much as better annotation corpora available for everybody in open government data or linked data.
Mm-hmm. Thanks. I mean, just to add on that, I would also give the lawyer's answer. It all depends. I mean, one of the things we saw also in Giovanni's talk is how long some of these basic categories have been with us and how much they still shape how we think and structure our world. And that is also, I think, again, for me, one of the interests of ontologies. Very often they do describe not just text and not just rules, but the way how cognitively we structure our world, how we perceive them. So there's, I think, an underlying and enduring and cross-cultural, cross-jurisdictional reality underneath it that ultimately informs some of these. And there you obviously can expect a relatively high degree of consistency and persistence. So the further you get down into the nitty-gritty and the detail where they add more value, you're obviously right. You need to invest much, much more in constant updates, in making sure that they remain an accurate picture. I mean, that raises for me another interesting question, less on the technology side, but on the sort of future of our profession, because it seems to me still the people, the organizations best placed for that are the large legal publishers, who also were obviously with AI and law community throughout the winter of AI that Enrico mentioned. So I don't think we will see the end of lawyers, but we might see them employed by different organizations. And one of them, for me, very, very clearly, are going to be the legal publishers, because they can automatize these updates, they do them as a service. And that raises all sorts of regulatory questions, obviously, the shift from
Burkhard,
a regulated profession to an unregulated one.
Burkhard, we have a question from Cecile Gursch. For what are legal ontologies good? Helping designing legislative initiatives, automating decisions, helping simplifying legal acts in the European Union environment, how they can improve the legislative process. That's the other question. Also, when you see the publishers, it's quite clear, but also for the lawmakers.
that one obviously goes to Monica, I would say.
Yes.
Okay, first of all, also Enrico stressed in the presentation, there is a problem of linguistic, multilingual in such cases, and ontology is good also to maintain aligned the definitions, for instance. So in Italy, we have a huge amount of terminology for the same legal concept, plenty of conflicting definitions. And ontology can help a lot during the legal drafting to use the same definition, the same terminology, if the case, obviously, or to make conscious of the lawmaker that exists already some definition and the conceptualization of the legal knowledge. And also Giovanni said before, this ontology in the light ontology level can also help a lot the lawmaker to avoid mistakes in the relationship of the concept and some very basic logic rules in description logic.
Monica,
So, yeah?
there's some additional question. You said you need people. What's about computers? Can they do the work too or not? What's about automation?
Can you repeat?
Automation. Can you automate the whole process in creating, updating ontologies?
Okay, so automatic updating of the ontologies, I think we need interpretation of the lawyers time to time, so it's not fully automatic, the process. The Commission is investigating the use of artificial intelligence and also to automatize as much as possible the legal drafting and the lawmaking system. But for now, it's not possible to replace the lawmaker totally using rules and legal ontologies. This is my view. But we can help a lot, all the process to be consistent, coherent, without repetition, errors, and improve the accuracy of the law-making process in the total steps, especially in the interaction between authorities.
Monica, there was an additional remark on that, also interesting, agility of law, because in Austria, the moped, a bicycle with a motor, was called a bicycle with a motor for a long time, and very later they used the real term. So maybe that's particularly in the European context important, that they have a proper terminology updated on a regular basis, and also what Burkhard mentioned, we should use the terms that people use, not so much our own legal terms that are so much more better, but not used by anybody besides lawyers.
There was also intervention for Victor.
Yeah, because if I may say something, automatically building ontologies may be possible, if not now, in the future. But I don't think it's going to succeed for political reasons, especially in this legal domain. Why? Because more and more we are perceiving reality mediated by artificial intelligence tools, and we affect our universe through artificial intelligence tools. And if a concept is in an ontology, this concept exists. If it is not in ontology, it does not exist. So in a way, ontology is ideology. You want this concept to be in a certain ontology. You want this to exist. And I do not want the output of an automated algorithm that is telling me this should be here. No, I want this to be here. Yeah, so this will be used to impose reality. It will have existence in the Luciano Floridi's infosphere. Yeah, some things we want to be there, some things we don't want to be there.
Yeah. I mean, it is really interesting. Just to open this up to the slightly more unusual domain. We are all familiar by now with the idea of code as law. The idea that we want to inscribe or hard bake directly rules into some devices. And we could, I think, start asking if it is totally true what Erich just said, that the the addressee of legal norms are necessarily always only humans. We could think of the addressee as being a device that is told to behave in a certain way. And the moment we do that, we can move from code as law to law as code, having a different type of drafting altogether, under the assumption that it won't be humans that read it, but directly machines. Now that is heretical, and I'm not in favor of it, but I do think it's an interesting thought experiment, how we would move beyond the history of drafting that goes back hundreds of years to one where we are not totally sure any longer who the audience actually is.
Yeah, that's a good remark for the future. I guess now human rights of human people take over. We have our break of 10 minutes, and then we have our last panel. So, Burkhard, thank you so much for sharing it. Thank the participants for these excellent talks.
Thanks, everyone.
Questions?
Thank you so much.
Thank you.
I'm in favor of law as a code.
And the whole panel, they have done a great job, because we got remarks in the chat. Great job, great panel. So thank you so much for being here and joining the conference. So we have a break 10 minutes, and then we have our last panel. Thank you so much. Bye-bye.
Thank you. Bye.